Hello, I'm Heidi Thompson, the Legacy Lifeguard with Lifeguarding Legacies. And I get to talk today about the 5 mistakes that people make in their estate plans. And a lot of us will make these instead of leaving the gift we intend for our families, we end up leaving a mess. And so today, my job is to teach you how you can avoid leaving a mess to your families. So let's get started. The very first mistake that people will make is they'll fail to avoid the ruthless raise of probate. So let's just jump right into the water here. If you've ever watched rays in the wild or in one of those petting zoos, you're probably like me and you just think they are so elegant. I am completely mesmerized as the way that they soar through the water. They make it look so effortless and they seem so harmless. But Steve Irwin, we all know the Australian crocodile hunter, he proved that even the most experienced nature lover could end up feeling the fatal sting of these beautiful creatures. Now, Frank, who's going to be our example today for this first mistake, his mistake wasn't quite as big as Steve Irwin's. He didn't underestimate the rays of nature, but he did underestimate the rays of probate, and it ended up stinging his family. So Frank made the first of our top 5 estate planning mistakes. He believed a will was all that he needed. He didn't consult with a lawyer to make sure that his asset protection plan would really work for him. So all he really owned was a home and the goods in it. He was a single guy, and because of that, because he didn't make any plan for this home, it triggered a probate on his death. And in Arizona, those numbers, and they vary state to state, but they're usually somewhat similar. In Arizona, if you have more than $100,000 of equity in your home or more than $75,000 of property in your name that doesn't somehow get automatically to someone else through some kind of appointment or beneficiary statement or something like that, then those things have to go to probate, and then the state gets to decide how to distribute your stuff. Now you'd think, well, he had a will, he decides, kind of. But in the meantime, there's this 4-month period when during probate, creditors get to swim around just like those rays and make claims against the estate. In the meantime, his estate is locked up with just a few exclusions and allowances, and otherwise accounts really aren't supposed to be messed with. So during this time, there will be $3,000 to $6,000 in legal fees, and if anyone contests anything, it can be tens of thousands and even up. It's a hassle and it's a burden on the family during a time when they're still grieving Frank's loss. So, we talked a second ago and said, well, but he left a will. Well, here's what we need to know. A will is really just a letter to the probate court. It tells them how you want your assets to be distributed. By itself, a will doesn't avoid the probate court. A will plus good estate planning can be enough. So, for example, if the house had had a beneficiary deed, then it would go automatically to family members, and the probate court wouldn't have that asset in it. Um, the other option is a revocable living trust. So let's talk about that trust. First, I know it's kind of a long name, but revocable, it means you can change it during your lifetime. You can move assets around, you can take things in and out of it, you can rewrite the whole thing. Second, it's living, meaning that it doesn't die. Because it doesn't die, anything you put into it doesn't go to probate because on paper, it doesn't belong to you. Yeah, you still control it. Yeah, you still get to use it. Yeah, you can still do anything you want with it. But on paper, it doesn't belong to you. It belongs to the trust. Here in Arizona, the laws on the books are that an estate put into a trust can go on for 500 years or until all of its purposes are fulfilled. Now, not all states go that long, but even if it only goes for a lifetime plus a standard 21 years, which is kind of a standard thing dating back to English law that we really don't have time to for today. it's still a long time that your assets can be provided under the things you set up. So if we don't want to be frank, it's a good idea to make sure that we've got a good trust in place. So now let's talk about the second mistake that people make, and that's failing to prepare for the jolting jellyfish of incapacity. Now, I've never been scuba diving. I really thought I would once. One time in Cabo, I even went through the short training. I had the wetsuit on, I practiced the breathing, and I was ready to jump off the edge of the boat. And the instructor who got in the water in front of us started having this look of terror on his face. And then we could see in the water that he was being shocked over and over and over again by these jellyfish that were all around him. And even when I think about it, I kind of get those empathy pains. It doesn't feel so good. Um, Thankfully, the rest of us, the lesson was canceled and we ended up going snorkeling for the day. Well, some people have the mistake of believing that estate planning is all about planning for death, and that would be mistake number two, which is failing to prepare for the jolting jellyfish of incapacity. Now, a lot of people at this point are going to think, I'm not old, I don't have to deal with incapacity. And if you're thinking about dementia and that kind of thing, you might be thinking, well, I don't have to worry about that. I'm still young, I'm still healthy, my mind is still good. I can put this off. But let's say you're in a serious car accident and you can't communicate. Maybe you passed out on the scene. Maybe you're even in a coma and the ambulance takes you to the hospital and you are unable to sign those documents when you're first admitted. If this were to happen to you and you don't have the documents already in place that allow the people that you love to talk to a doctor on your behalf and make your medical decisions, um, then if you're over 18 and don't have those documents, you become a ward of the state, just like a foster kid. To gain a legal voice to act for you, then your family members may have to go to court, pay the high legal fees, and have that loss of that critical time seeking guardianship for you through the court system. That really stings. And it's sadly sudden and unpredictable, just like those jellyfish. But you can choose jolt free waters by just making sure that you've got estate plans in place. Now, everyone who's an estate attorney who has any reputation will make sure that your will or your trust will always include those supporting documents, which include your healthcare power of attorney, letting the person make those healthcare decisions for you, a financial power of attorney, which allows them to pay bills for you and take care of working with insurance, and then living wills, which does make those end of life decisions so no one else has to make those for you, and then HIPAA waivers to be able to speak to a doctor on your behalf. That brings us down to mistake number three. Now, I found this video on a National Geographic YouTube channel. It shows two moray eels spinning around as they fight to the death. It's one of those, I don't want to watch it, but I can't take my eyes off it kind of videos. Now, back in the day, I used to work in high schools and my mind went to a couple of teenage girls fighting over a boy, that here, hold my earrings. These vicious creatures are seeking to cause the deepest harm they possibly can. And that is mistake number three in estate planning, believing that your kids will get along after you die. There's an old joke in the legal world. Criminal law is bad people on their best behavior. Family law is good people on their worst behavior. And estate law is nothing but family law with money. Yeah, it's not that good of a joke. And it's not really that funny. I've seen it. Families that seemed perfectly amicable, they spend Thanksgiving and Christmases together, no real major dramas. Then mom passes. And there's always one object that at least two people want very badly. One was promised it, the other might already have it in their possession, and then the fights start to get ugly. Now, we like to think we're not tied to possessions like that, but the sentimental pull of some objects is actually stronger than you might think. One lawyer even tells a true story about how a family ate up a majority of the estate's money, very large estate, because of a $3 vacation knickknack that had sentimental value to 5 children. It was a little Hawaiian dancing monkey that mom had from a trip that the family all took together that she made a big deal of throughout their lifetime every time she was celebrating a child. So it's not always the expensive things. It's not always the things that you would think would be of value, but it's anything that has that sentimental connection. So the only way to really limit those disputes with your family is with some pre-planning. So talk to your family members now, learn what objects carry that kind of strong emotional value. And while mom is alive, it's a lot easier to mediate these disputes and make those decisions than when she's gone. When you make that plan to distribute your assets, you'll limit the fighting and you'll leave this world with your soul and your family at peace. So let's talk about mistake number 4, suffering the pirate's curse. Now, I think Johnny Depp is the best actor of all time. He's not necessarily the cutest, not necessarily my favorite, but I think he's the most talented. There was a meme once that was all over Facebook, and it had him pictured in a lot of different roles. And they said I could be anything I wanted when I grew up. So I did. And it showed him as that weird kid with the scissors on his hand, the Indian, the Willy Wonka character. But like you, my guess is his most favorite and most popular character was Captain Jack Sparrow in the Pirates of the Caribbean series. Jack made pirates likable. At the end of the first movie, in The Curse of Black Pearl, there's a scene where he and a cursed group of skeletal pirates find a heap of buried treasure. And these coins were cursed if they were removed from the chest. Just like that, a large treasure can be a curse in real life. We all know the stories of millionaire lottery winners. They're almost always more broke 2 years after they bought the ticket than they were beforehand. Most people just don't handle great wealth that's suddenly received. It takes years of training and positive habits to manage money well. And yet, most of us will leave an inheritance as one lump sum, even if it's just the value of our own home. In most cases, this is not leaving a legacy. It will be used and spent within 2 years as if it were cursed. Lump sum distributions are really estate planning mistake number 4. So if you have large investments like 401ks, IRAs, large bank accounts, or real estate, think about how those might be divided and spread over time. In my case, I follow the Warren Buffett philosophy, which is you should leave your children enough so they can do anything, but not enough so they can do nothing. I want my kids to have to work for their living. When I'm gone, I want their lives to be enriched by what I gave them. So my trust is set up to give an adjusted amount every year. Um, that's about $15,000 a year. That's $1,250 a month. It's below the poverty line by a fair bit, but it's enough to buy a decent car every few years, enough for a kitchen remodel, enough for a few nice family vacations, enough to pay off some stupid credit card debt. Basically, it would enhance their lives without substantially changing them. Now, I will confess, there is a little bit of a complication in this area. It was a game changer. In December of 2019, when the rest of the world on TV had their eyes on the first round of the President Trump impeachment trials, Congress snuck through the Secure Act. And this has really disrupted my industry. Basically, the big takeaway from this is that when you inherit 401ks and IRAs and you're not the spouse, if you're a spouse, it's still fine. It's still a great inheritance vehicle for spouses. But if you're a kid inheriting your parents' 401k or your IRA, it has to be fully distributed and taxed within 10 years of when you receive it. So in 10 years of when your parents die. Now, if you're under 18, it delays until you're 18 and the 10-year clock starts then. But still, for a lot of us, if we think about it, if our parents are dying in their 70s, that means we're in our 50s, and that means we're in our top earning years and our highest tax brackets during the years we're receiving this. So again, that's not great news for us that those are the 10 years we have to receive it. Used to be we could stretch it out for our lifetimes, and it was not that kind of a thing. So this is one area where it's really helpful to meet not just with your estate planning attorney to get some of that advice from us on how it might affect taxes and everything else, but work as a team with your financial advisor and even your CPA. When we put those heads together, we can make sure that the things that are distributed make sense. So the things that need to be distributed first can be distributed first in ways that make sense, and then bank accounts, then the home sale, so that your children can experience the benefit of your legacy throughout their lifetime and not experience that pirate's curse. Now, there is one more thought, um, and that's about silver marriage. Silver marriage can complicate your estate plan. And what I mean by that is, you're married young, you live your lives together, one of you dies and the other one marries later in life. Your kids may be grown and self sufficient. So you and your spouse built this great estate plan for the benefit of you and your kids. And so when one of you passes and then finds love again and marries, they can actually potentially leave things to the new spouse and the new spouse's children instead of to the children it was built for. So, in my world, we have fun names for this. The one I like to use is the floozy clause. The way I explain that to people is that my husband, very good looking man of 52, still has a nice full head of hair, has a nice 8-pack from working out. Yes, yes, ladies, I just could beat you up with a stick. He's a wonderful man and a good provider. And everything we built, we got married young and raised our kids young. Everything we've built together. And it's really intended for our kids and our grandkids. And I have no doubt that if something happened to me, some cute young filly, said Floozy, would put herself into his path and may still want to have kids or may bring kids into that second marriage. And it's not my intent that all of that would go to her. So there are things I can build into a trust or other estate planners can build into a trust that make sure that when the first of you dies, the trust becomes irrevocable to the portion that goes to the kids so that it's protected. And so you can still live off of it as the surviving spouse. Your new silver marriage partner will still have incidental benefit, but won't be able to expect anything when you die, so that your kids still get the inheritance that you've built for them. And that's not to say in that second marriage, you couldn't do a whole nother plan with them for any new community property assets. It just is a great way to protect your kids from that kind of a thing. All right, that brings us down to mistake 5, the last of our 5 mistakes. My husband believes that Google is the evil empire. He's a bit of a conspiracy theorist, and sometimes he really doesn't seem that far off. I won an Amazon Alexa device as a door prize, and he wouldn't let me plug it in because he doesn't want to add more ways that our conversations might be listened into. Even so, I can't tell you the number of times we had a private conversation about buying something, and then all of a sudden on Facebook or Google, there's that item. One time I was at a pool party talking about a place I'd never been before on vacation. The next day, there's 3 resorts on my Facebook feed in that destination. Never even really talked about going there before. Kind of creepy. Well, nonetheless, I still think Google is pretty amazing. You can ask just about any question and get an instant and usually right answer. Now, I'm old enough, yes, I'm aging myself, to remember having a set of Encyclopedia Britannicas in my parents' home growing up. And anytime they couldn't answer a question, they were like, go look it up. Now all I have to do is hit a button and Google comes to the rescue. It makes perfect sense that you might Google a will form and fill in the blanks and sign it. And legally, it might even hold up. Emphasis on might. What you don't know is, how old is that form? Does it really meet the needs of your family? Is it specific to the rules of your state? Does it take into account current law? Who wrote it? And were they any good at what they did? So I think mistake number 5 is swimming with no lifeguard on duty. Now, realistically, I could probably create a will form. I've been doing this long enough that would serve its basic purpose. But even with my legal training and experience, I wouldn't do that. I use solid core documents that are really proven in the industry, and so do a lot of my colleagues. They'll use good core documents from a really trusted source. That makes a big difference because you know that that company stakes their reputation on ensuring that everything is up to date, state specific, current with law, and that they're doing good training around the use of those to make sure that nothing is misused. And If there's no one to walk you through some of those questions, even things that seem straightforward, you might miss. For example, do you want the trust to be irrevocable upon the first of you to die? Well, most people would say, no, I want to be able to change it. Well, guess what? Now that the floozy clause, remember that? She can go and make changes in favor of her new family. Probably not the result we want, ladies. All right, so please make sure you have a lifeguard on duty. A good estate attorney will throw you a lifeline that protects you from all the dangers of the deep. So if you don't make that mistake, you won't be swimming at your own risk. Now, speaking of swimming at your own risk, procrastinating or trying not to think about the realities of this topic is just as dangerous in swimming in those waters. So try and pick an attorney that will make this like a day at the beach, listening to your questions, making sure they get out of you the right answers, and making the process simple start to finish. So, the good lifeguard will save you from the 5 mistakes in estate planning: the ruthless raise of probate, the jolting jellyfish of incapacity, the war waging eels of family strife, the pirate's curse of outright lump sum distributions, and swimming with no lifeguard on duty. I so appreciate the chance I've had to spend this time with you. And thank you for attending this women's conference. I hope you'll stick around and see all the inspiring women and the passions that they have to share with you. It's been a joy, and I look forward to talking to many of you again soon. Thanks.